live streaming is on. Court rise.
Right. Yes, Mr. Kimley.
Thank you very much. As to grounds 47.
Yeah.
When the senior president was dealing with Hopkins in the Court of Appeal, the way that my lord approached it was to say, well, we're not really occupied with resolving differences between differing judgments and interpretations. What we're doing is we're interpreting the policy, and that's what grounds 4 to 7 are about.
Yeah. Right.
And in that regard, can we turn up, please, in the supplementary bundle, what the government said about this? Sorry, actually, it's in the core bundle. In the core bundle.
Core bundle.
Core bundle, what the government said about policy when it first alighted upon it and when it modified it. Tab 12.
Yeah.
And just so that we understand what we're in, page 170 is consultation on the NPPF, and we can see at the bottom of 171 the date, July 2011. So this is the government announcing what it's doing. And if I may, can we go to 178 to draw attention to paragraphs 15 through to 18, where the document starts off by explaining that it's going to introduce the strong presumption, third line, which is going to have a key role, first line. Key role for the planning system is rebuilding the key is used again in the last sentence. This is a key part of our package. So the strong presumption is a key part of the package for the key role of the planning system in the economy. And it's going to be at the heart. It's fairly emphatic. We're then told, 16, that the top priority is to promote sustainable economic growth and jobs. And the way in which this is to be done is explained. It's at the end of this paragraph 16 that we get the resonance with the policy we're concerned with, because the Chancellor made clear in a budget statement that the answer to development and growth should, wherever possible, be yes, except where this would clearly conflict with other aspects of national policy, reminiscent of 11D1, clear conflict. And I draw attention that all that is referred to is national policy. And at 17, we're told about the presumption being turned into policy that works with the existing plan-led approach by emphasising the role of up-to-date development plans in identifying and accommodating development needs. And this is what I call really, I said I'd refer to the word contingency again, and I do so now. This is really a contingency. Where those plans are not up to date or do not provide a clear basis for decisions, the policy establishes a clear presumption that permission should be granted. And then we get the words we're concerned with now in 11D2, overriding conflict, the framework as a whole. So, in paragraph 17, again, we get reference only to national policy.
Yeah.
Now, draw attention to
Just pausing.
Yes.
This is consultation that preceded the first NPPF.
Yes.
Now, are you in any way praying its aid in construing the words of government policy in the third version of the NPPF, published 8.5 years later, 7.5 years later?
My Lord, the answer is yes, and it's in respect of the second version.
But how is that a legitimate tool to construction?
If I needed authority, I would go to Red Hill Aerodrome.
Well, Red Hill, Lord Justice Sullivan says, if the government's going to change its policy in a material way, one would expect it to flag it. I paraphrase. I don't see how that helps you with my question.
My Lord, the take it in stages. One is as a matter of principle, secondly as by reference to Redhead. As a matter of principle, to understand the intention of the policy is in my submission clearly relevant, particularly where one sees very clearly expressed the scope of that, the ambit of that policy, and where one is then also dealing with the contrary position being put by the Secretary of State. My learned friend Skeleton argument says it was the intention of the Secretary of State that development plan policies should be included in 11D2.
Yeah.
So it's an answer. In my submission, I'm entitled to rebut that, and I want to make it clear I do not accept that that was the intention because of this document. Secondly, as to Redhead, we haven't got it in the authorities, but Lord Justice Sullivan in that case, in interpreting what is now 144 in the current framework, was very clear in having regard to a consultation document to assist in construction. That's what the Court of Appeal did. And while it is different to, it's not so very different to the exercise that we've been engaged with in part this morning, looking at a previous document. It's my Lord's point put to me the other way around. To what extent is it helpful to look at a document prepared 7.5 years earlier? Well, my Lord, may I explain my reference to second version, just so that I'm doing. We have 2012, 2018, 2019. 2019 NPPF was only changed in very technical, minor ways. It's essentially the same, except in respect of house regs, and a little bit to do with how one counts houses. So, the need for houses, people. So, in my submission, it is instructive and assists the court in understanding where government is coming from, and then to look at the degree to which it either says it continues with that intention or it wishes to change it. And that's exactly what we get from the document which follows on, starting at page 182. In March 2018, 182, the government consulted upon changes which we've been canvassing during the course of this morning. And I wish to take the court to two parts of that consultation. Firstly, the introduction, which starts at 187, where the sidelined first half of that page essentially says there is a very substantial problem in providing sufficient houses for the country. With that starting point, page 188, the first full paragraph starts, the government is ambitious. So it then takes that material and says, government is ambitious about reforming housing and planning policy so that it is as effective as possible in improving the supply of homes. Therefore, this consultation includes a number of further changes to policy to help ensure that more land is brought forward and permissions are turned into homes as soon as possible.
Before you move on, Mr. Kimball,
My lady, yes.
page 187, towards the bottom of the page, this new framework implements the government's reforms, and it's incorporated, top of the page 188, the effect of case law.
Yes, I ought to have drawn attention to that. In my submission, that undoubtedly refers to Hopkins, and it picks up other cases where there were some decisions of the Court of Appeal in respect of Greenbelt, which resulted in changes.
Yeah.
Then, over the page on 189, Chapter 2 is introduced. But before that, we have a summary of proposals. And firstly, it draws attention to the establishment of the presumption that we're concerned with. It tells us in three bullet points what the revised framework is about. And I draw attention to continuity. However, there is much continuity, and the presumption is expressly referred to, and we get the same language, remains at the heart of the framework. We'll recall that from what we just looked at. So the submission I make is that that which we had in 2011 continues and remains at the heart. And then specifically in respect of chapter that we're concerned with, the first change which is highlighted at the bottom of the page in the second line is the reordering. And then I draw attention at the top of 190, the current framework, which is the case law amendment which my lady picked up and which we canvassed during the course of the morning. And we get a defined list in now footnote 7. I draw attention to this approach does not preclude other policies being used to limit development where the presumption applies, when we get to the text of 11D2. What does that mean? In my submission, the use of the word policies is plainly the same as the word policies in the first line. Policies in the framework.
But it's other policies. Does your interpretation ignore the word other?
My lady, no.
What is it other than?
So it's other. The word other means other than those which are specific policies in footnote 7. The remainder of the framework, what it's emphasising is that the remainder of the framework may be enough to disapply the presumption. And that's really why it was, if I can put it this way, sensible to reorder the two points after the word unless. So I submit that...
Does it anywhere say... I'm sorry, you make the submission, then I want to ask you a question about it.
I'm grateful. The simple submission I was going to make was that the interpretation we contend for is on all fours with the material I've taken the court to.
Well, that really sharpens the question. Is there anything in the consultation document that specifically addresses the point that we're considering?
No.
Right.
These were the consultation proposals. Is there anything after the proposals that you rely on?
I suppose I'd simply draw attention to what they say would happen happened.
Yes, the NPPF, the new NPPF.
Yes. And so that's what we got in 2018, and then it carried forward to the 2019 version. And there's no change whatsoever from then on.
Yeah. Well, there was a revision published in July 2018, I think, first, and then the January 2019 version. Right?
So, consistent with intention, do not accept that intention was anything else. The interpretation which we contend for is essentially simple, and it is founded on those features case law in respect of the NPPF generally, which are just so familiar to the court. It's a material consideration. It is outside of the development plan. And secondly, it's drafted, it's dependent upon the clear drafting, we would say, in 11D. Because 11D is set up as the presumption, so we can be completely clear, the presumption in this instance, or in these, if you're in 11D territory, is that you grant permission. That is the presumption. That is the tilt which one obtains in the language which we have developed. And what follows in 11D2 is not itself the tilt, it's not some overarching balancing exercise. It's two ways, or in the way that Lord Gill put it, two grounds on which it may be disapplied. And in 11D2, our submission is that that disapplication is in respect of the policies which are in the framework, taken as a whole. Now, there are two or three main ways in which it is said by the Secretary of State that one ought to arrive at a different interpretation and interpretation by reference to the policies in the framework. They are paragraph 14 in respect of neighbourhood plans, which we've touched upon to some degree, paragraph 15, which is the introduction to the next chapter, and paragraph 103, which is a transport-related policy.
Sorry, 103.
103.
Yeah.
If I could invite the court, please, to turn to paragraph 14. There are some very short submissions in respect of paragraph 14. It's page 121, tab 9 in the supplementary bundle.
Right, we're putting away the consultation now. And you want us to look at paragraph 14. Might just observe at this point that we haven't spent very long yet on paragraph 11 itself, which is a strange feature of the proceedings thus far. But perhaps we're coming back, are we?
Yes, by all means. So 14,
Yeah.
I submit, is that species of paragraph or policy in the framework which is very clear in directing the decision maker in a particular way. One identifies a wide variety of types of paragraph doing all sorts of different things. Some of them aspirational, some of them procedural, some of them just reminding people of things. This is really a policy directing, so far as policy can direct, the decision maker. And it does so as against criteria which are very clear and precise. And the ambit is similarly clear and precise by reference to neighbourhood plans. And for the same sorts of reasons that I submitted in respect of Crane and the former 198 and 183 to 185, I submit that one takes account of paragraph 14 in the context of paragraph 11, just going back one page, for the very simple reason that 11D2 directs one to the policies in the framework. It's a policy in the framework, you do what it says. compare and contrast, if I may, 1 to 2, we have paragraph 15, which is the first paragraph in chapter 3 on plan making. And the Secretary of State relies in particular on that sentence, planning system should be genuinely plan-led, which is not directing the decision maker to do anything, not least, of course, because it's in a section concerned with plan making. It's a statement of intent, it's an aspiration.
Yes, but the plan-led system really connotes, as a concept, the duty in section 38(6), doesn't it?
Absolutely, which the framework itself acknowledges and announces, remains in place and will be dealt with via a finding against the development plan, and then this comes in as a material consideration.
Yes, but in making this general reference to a plan-led system, as did the previous version of the NPPF actually, I think in paragraph 12, the NPPF is acknowledging the role of the development plan as pervasive in decision making, all-encompassing.
I have no difficulty in accepting that point at all.
Right.
It's the foundation of the system.
But, I mean, is the submission really this, that this just isn't specific enough to colour the application of paragraph 11D2? Is that the point?
Well, I'm grateful for that characterisation of it. That's very much the submission, that it's not difficult to spot something which tells the decision maker what to do with paragraph 11. And the second submission I would make in that regard is that if the position were otherwise, then the Secretary of State would very easily have inserted words to make that clear in paragraph 11. It's not a difficult piece of drafting at all.
What about this proposition then? The Secretary of State evidently didn't perceive the need to do that because the Supreme Court had spoken on the point.
Point one.
Hence the reference to case law, or reinforced by the reference to case law.
My first response to my Lord's question is that, firstly, the wording was alighted upon pre-Hopkins, self-evidently. And my submission is that if at the outset the Secretary of State had wanted this ground of disapplying to be inclusive of the development plan, that would have been stated. My second response to my Lord's point really takes us back to submissions before lunchtime as to the extent to which, on my submission, Hopkins Holmes engaged with this aspect. But I don't propose to rehearse those submissions. I do submit that it is, if I am wrong in my submissions, if my submissions are incorrect, it is a quite startling outcome that in this paragraph, only text box in the document, absolutely crucial and central to the planning system, that something as important as the development plan gets left out by accident. That would be, in my submission, a startling omission.
But paragraph 14 of the 2012 NPPF had it in a box and coloured, and it didn't refer to the development plan. And as we've seen, the Supreme Court said development plan included.
Well, my Lord,
So it's no more stop than that. I mean, I understand the point, but there we are. It wasn't persuasive in the Supreme Court.
well, it's the second opportunity I've had to go back to that this afternoon, and I'll resist the temptation again to do so. Tempting though it is.
But as I understand it, your submission is that the 11D 2 only engages with policies in the NPPF, and therefore development plan policies only become relevant if they are, as it were, drawn in by a provision in the NPPF. And well, I meant to say this, you must disagree if this is not your submission, but you say that the only way in which it is in paragraph 14.
Yes.
What about 104? I thought you...
103.
Oh, 103.
Well, 103 is relied upon by my learned friend, and I respectfully disagree.
Ah, okay, sorry.
So there appear to be three paragraphs which are in play as Secretary of State's case is that 14, 15 and 103 undo my argument. That's the Secretary of State's position. And I say 14, no for the reasons I've given, 15, no for the reasons which I've given, and 103 is...
So, just before we look at 103, we're going to do that, of course. So should the government, do you say, have qualified 11D2 by a specific reference to paragraph 14?
My Lord, no. There's
no need to do it.
There's no need to do that because it says refer to the policies in the framework. Paragraph 14 is a policy in the framework. It has to be applied.
So the development plan comes in silently in that way?
Because it might be put in that way, my Lord, yes.
Well, when I use the word silently, I mean without being announced. And you say it doesn't need to be announced. In it comes.
Well, what happens is that a carefully boxed off and carefully prescribed policy is in place, which influences that disapplication. And that is concerned with a plan which is a part of the development plan.
But what's the policy reason for giving precedence to certain policies that are stated in the NPPF, which doesn't have statutory force, and not to development plan policies, which do have statutory force?
My lady, there are broadly two answers to my lady's question. Can I deal with the neighbourhood plan part first? If I've understood the question. Perhaps my lady's question is this, which is, why have 11D2 referring to policies which are only material considerations and leave out those which have the force of section 38.6?
Yeah.
Well, the policy reason, there's only one answer to that. The answer to that is that plans do not always work. Plans do not always deliver. And what the framework does is make it plain that development needs must be met. And the policy deals with those circumstances, which can be many and various, of course, where development needs are not being met, or there's a wide variety of purposes, or the development plan isn't addressing the question which arises, and it seeks to make plain to decision makers that where those three circumstances in 11D pertain, the answer is yes unless. And it's set, this is the real answer to my lady's question, it tells the decision maker how one should assess those questions of unless. And national policy is the answer. And that, in my submission, is evidently sensible, because one is so often dealing with circumstances where the development plan policies, for one reason or another, are not delivering or answering the question. And that brings with it no pejorative aspect so far as the particular planning authority is concerned. It can come around for all sorts of reasons. One thinks at the moment of authorities such as Herefordshire or those onto the Solent, where development can't happen because of nutrient inputs causing waters to go green, and those waters are protected. And by operation of law, it's not possible to grant consent. So there are all sorts of reasons that can knock plans off course. And this is, in many respects, a contingency either as to gaps in development plans, forms of development which just don't feature in policies, or policies which are no longer delivering need. As we identify from paragraph 11 itself, for plan making, sustainable development means meet the development needs of the area. And so, as I say in the skeleton argument, I concede that in some respects that might be a rougher assessment than against perhaps finer-grained policies in a development plan. But the policy imperative is to meet the development needs of the area, and that's why D is there.
There's nothing in, I don't want to go back to Hopkins Holmes. I just want you to confirm that I'm right. That there's nothing in Hopkins Holmes, is there, which draws in development plan policies by reference to paragraph 198. I don't think there is.
I agree. There is.
So the new NPPF, where the restriction, where the reference to development plans, so far as your submissions are concerned, moved from 198 to 14, was a dramatic shift, wasn't it? Because 198 brings in development plans in all parts of neighbourhood development plans, whereas 14 is very restricted because it has 4 criteria, all of which have to be satisfied. So it's a big change in practice from allowing all of these these local policies in to allowing really very few in. That's just in practice what happened.
Lord, yes. Yeah. It is what happened. It is. Very much. Miss Osmond-Smith describes it to me as an evolution. She's right. It is an evolution, but it's quite a, as my Lord says,
it's an evolution from a,
yeah.
you know, sort of, well, it's a big step in evolutionary terms. But there we are. I mean, that's your submission.
It is.
Yeah, I mean, I may be going off the point, probably am, but one of the stark features of this is that for all that's gone on before, the drafter of paragraph 11, and if I may, I'll take us back to that, or to that, quite distinctly does not apply footnote 6 to paragraph 11d2. I mean, it's striking, isn't it? That is very deliberately not done for paragraph 11d2. And the drafter has been alert to what the footnote says, because the drafter has now inserted the parenthesis in footnote 6 rather than those in development plans. So it's quite clear that a mind has been at work here and has applied that footnote only to 11d1 for present purposes. Well, how do you explain that?
With respect, it's it may be a point on which Mr. Honey's better placed to answer the question, but I will have a go because it's his client that drafted it.
It's right that we should give you the opportunity because
Yes.
it is perhaps a really striking feature of the drafting.
My Lord, I would not place the emphasis on it which my Lord's question suggests might be.
Right.
For these reasons.
Right.
The first of which is that we have paragraph 40, which is in a very carefully prescribed way addressing the development plan. And it has said that particular part of the development plan, in those four circumstances, is in play.
But you could still have footnote 6 applying to paragraph D2, and paragraph 14 would apply because paragraph 14 is a paragraph in the NPPF itself. It doesn't matter that it may also feature in a development plan.
Well, my lady, with respect, no, because paragraph 6 would have to say something else. Sorry, footnote 6 would need to say something else if it applied to 11d2, because 11d2 deals with everything else in the framework. I agree that it would be possible to have a further footnote after, so it would be footnote 8, which comes at the end of 11d2, which says the policies referred to are those in this framework, not the development plans. That would be possible.
And that's really what I'm putting to you. It's the same point.
It is the same point. Well, what I would, the alternative approach which I'd invite the court to take is to understand this as when the person drafting this had made it abundantly clear, if it wasn't clear before, that 11d1 was about the framework. One would not expect anything different in respect of what follows on, in respect of the other policies. I put the question the other way around. Well, why on earth would you have a different situation in respect of 2 immediately following 1? There's no good reason that's been canvassed either below or in the judge's judgment to explain why that would be so. And so, in a way, I'm turning the question around, evident that it really is my answer to it. Would it really occur to anybody that somebody would then have to go into the trouble of saying, not the development plan, that it pops up immediately thereafter, when not referred to anywhere else in the whole of the text box?
Well, the answer to your question, if you want an answer from the court, might be this, that 11d1 is about very specific elements of the NPPF strategy, which the drafter of the NPPF strategy knows are encompassed here, and they are the policies, really, you might say, of the highest degree of protection. Last week we were looking at paragraph 172.
AOMB.
Yeah. Whereas, by contrast, policies encompassed in D2 are much more broad-ranging. Indeed, they are entire across the spectrum. And it is in that context that a broader approach, allowing for development plan policies to be taken into account, is not only perfectly apt, but perfectly necessary. That's the answer.
Can I deal with that by reference to apt and then necessary?
Or maybe the answer. But by all means, do with it.
My Lord, the simple and straightforward point so far as apt is concerned with is that on a plain textual reading, one doesn't get there. It's not apt, in my submission, to read into a policy document which the public relies upon words which have such a radical effect on the policy. That, in my submission, is not apt.
Well, they only have a radical effect if the starting point is that they shouldn't be there. But if you put yourself in the mind of the government drafter of this, whose intent to make sure that the tilted balance is applied in a complete rather than a partial way, and not in an artificial way, ruling out development plan policies that parallel or depart from, perhaps, or provide a tension with the policies of the framework, then you might get the answer that you suggest. But you might have to start perhaps with a more neutral mindset in approaching this question.
Because you're seeking to insert a word into D2. You're seeking to, after when assessed against, you're seeking to insert only.
My Lord, I'm not. No, my Lord, that's not correct. I do not seek, with respect, to insert the word only. And the word only is absolutely unnecessary to understand that the assessment is to take place against the framework.
And what else?
It states one thing. Assess against the framework. It states one thing, that's what you assess it against. And so far as there's any variation from that, the framework picks it up within its own policies. The reason I say it's not apt to go and insert such additional words in part is supported by Hopkins. Points I record in the skeleton arguments. But Hopkins is keen to say that one should not be creating legal fictions, still less should one be introducing language into national policy which isn't there.
So Lord Carnworth created a legal fiction of his own without knowing it, did he?
My Lord.
Well, I mean, that's implicit in your submission, tied with your earlier submission, or at least concession, whichever it was, that Lord Carnworth's paragraph 14, and indeed Lord Gill's paragraph 85, are, quote, intellectually wrong, unquote.
My Lord quotes me accurately.
Yes, I do.
In answer to the court's question.
Are those legal fictions?
They are.
Or non-legal fictions?
They are, as I've submitted, incorrect. So we get back to where I was before lunch.
Well, but you're making a submission now about paragraph 60 of Hopkins Holmes, in which a constructional difference arose between this court and the Supreme Court.
Yes.
And that's why Lord Carnworth, and it's right on the spine of his reasoning, actually, has to confront what paragraph 14 actually means. It's because of that constructional difference that he goes there. That's what Hopkins Holmes was about. So to suggest that it's somewhere away from the spine of the reasoning, the essential reasoning in Hopkins Holmes, doesn't work. So we've got to confront then what you accept is intellectually wrong, or suggest is intellectually wrong, to make your argument. And you're suggesting that the error is to be reading words into paragraph 11D2. That's the error you say was made in the court below. An alternative way of looking at it would be to say, well, it doesn't, by contrast with 11D1, rule out the development plan. The drafter has very deliberately, in the context 11D1, knowing what was said in Hopkins, as we know the drafter did, has very deliberately excluded development plan policies for the purposes of 11D1, but has not done so for the purposes of 11D2.
Well, if my lord and the court generally is concerned about that particular submission, can I expand it a little further by drawing attention, as my lord has observed, we haven't spent long on the text itself. D starts off by a reference to development plan policies. So it's expressly about development plan policies. Compare and contrast to 11D2, expressly about the whole of the framework. Read in context, in my submission, it couldn't be clearer. One starts off with a, well, my lord.
No, I'm not sure that a submission that 11D2 couldn't be clearer. Whatever the true construction is a very powerful one. I think D2 might have been drafted in a different way, that might have been clearer, one way or the other.
Well, in fact, with that observation, I would readily agree. But my point is a different one. My point is as to against what is the assessment to be made.
I understand that. On that point, can you help me with this? The formula, the form of 1 and 2 are completely different. One is the application of policies in this framework, and we know that they mean specific policies which are outlined in the footnote. The application of these policies provides a clear reason. 2 is not drafted in the same way. It doesn't say the application of policies in this framework. It refers to adverse impacts of doing so would significantly and demonstrably outweigh the benefits. Stopping there, if the drafting had stopped there, development plan is certainly in.
I agree. If the last 12 words go, it's in.
Yeah, correct. And then there are these last words, but they're in a different form from little 1. Are they conceptually different? You say they're conceptually the same, I think. I mean, you may be right, but
I make this observation because it may provide some assistance. It may be right, it may be wrong. The phrase "taken as a whole," I imagine, is important because it's telling the user that you're to make an overall judgment, and it's to deal with the potential for decision makers or others to say you don't get the benefit of the presumption because you're in conflict with a policy. That's not the exercise.
No, I see that. I see that, and I understand that point. It doesn't really answer the point as to why, if the difference in wording between the application of policies in this framework, taken as a whole or whatever, and what is said in little 2 is a conceptual difference. I think on the basis of your submission, and this is policy, so we can't construe it like a statute that differences really matter. I understand that, but it seems to me that conceptually you say that they're really the same thing.
I would submit, in fact, they're not quite the same thing, having regard to the way in which these 2 grounds, as Lord Gill put it, operate. Because 11D1 can produce a knockout blow so far as the presumption is concerned as against one policy. And so 11D1, all one has to do is apply the single policy, flood risk.
And you say
the presumption's gone.
Two requires an assessment.
Yes.
No, I see that.
So my Lord's question was about Are they conceptually the same? To that extent, I would submit that they're different.
Yes, no, I see that.
So the exercise is different. And what it's seeking to do in my submission is to capture the situation where there isn't a specific policy giving a clear reason. But when you look at national policy,
As a whole.
countryside, it's miles away from where it should be. No, this isn't what national policy is about, and you're not having the presumption. That's what 11D2 is about. And just so it's completely clear, all that does, if it does disapply, is take away that presumption.
What it's doing
Disapply it.
is telling a decision maker what the government says it should do when applying Section 38(6), isn't it? For decision taking, that means doing the Section 72, Section 38(6) exercise. Of course, it is a material consideration within that frame, but it is telling the decision maker how to go about making a decision. Yes?
Oh, undoubtedly, it has a very substantial, I would go as far as say it has a very substantial bearing upon the making of a decision for the reasons which were canvassed before lunch, as to the need to do certain parts of decision making in a particular order.
Yeah, but that's not quite the point that I'm on. The point that I'm on is that this is a policy for the way in which you discharge the Section 38(6) duty. It's about decision taking. Of course, it sits within that statutory frame as another material consideration. That is its status. But what it is purporting to do is to tell the decision maker how to make the Section 38(6) decision. For decision making, this means approving and in D, granting permission So it's about the performance of the Section 38(6) duty.
My Lord, the relationship with Section 38(6) is certainly very strong because it's about decision taking. I completely agree.
That's what the government... You say this is a key paragraph. It's a key paragraph if it is, because it's about the very business of development management, as we now call it. It used to be called development control.
Yeah.
It's telling the decision maker how to make the decision. Of course, its status is another material consideration. But what it's purporting to do is to tell the decision maker how to go about the Section 38(6) duty in the alternative cases with which it deals. Yes?
My Lord, I wouldn't go that far. I wouldn't concede it to that.
Well, how far would you go?
Description.
How far
I would
would you go?
submit is that proper interpretation of this paragraph is that it always remains a material consideration. It always remains a material consideration. And what it produces is either a presumption in favour or not, which, by reason of the policy, must be taken into account in Section 38(6). To that extent,
Well,
I agree with my...
I'm not saying more than that, I don't think. I mean, it's obviously creating presumptions, or a presumption. But that's inherent in its business. Its business is to tell decision takers or makers how to go about their business.
Well, I find myself in the position of submitting and inviting the court to be cautious about going too far with paragraph 11, because it's the development plan which is preeminent.
Of course it is.
And
I've entered that caveat already.
and so it appears that on this question at least, I'm achieving some common ground with the court in that really, if we are retaining this as a material consideration, it's not going too far into effectively interfering with the preeminence of the development plan, which always must come first.
Precisely. It can't do that
No.
because of its status.
Cannot
The
possibly.
statutory status of the development plan
Completely agree.
is enshrined, that's not too high a word, enshrined
Yes.
in the statutory scheme. This can't disturb that.
Never.
See Lord Carnworth in whichever paragraph it is, cannot distort, displace, etc. I think language which I'd used in an earlier case. You can't do that because it's only policy. And it's sometimes very easy to forget when we have these discussions, and there have been many of them. It's only policy.
I completely. That's the foundation of our case.
Right.
What it produces is a policy consideration, or not.
Right. Well, now we've asked you a great many.
Sorry, no, I was just going to say it's, and I may have misunderstood you, Mr. Kimball, so tell me if I have. You seem to be saying, though, accepting it's always a material consideration and it's preeminent and nothing can displace it because of its statutory basis. Nonetheless, it only comes in when you're looking at whether the presumption applies. It doesn't feature on the other side of the balance if there is a planning judgment and an assessment to be made. If the development proposal is in accordance with an up-to-date development plan, well, the presumption favours a planning decision in your favour. Where there aren't relevant development plan policies or they're out of date, that determines the presumption, but you don't weigh it in the balance. You discard it after that. Have I understood what you're saying?
My lady, I agreed with everything my lady said up until discard.
Yes, okay.
One
Okay,
very
discard was too strong. You discard it unless it features in the NPPF.
The way that I would put it is that D1 or D2 may discard the presumption. So if you've done that exercise in D2, the conclusion may well be that the proposal doesn't benefit from that material consideration, which is that the Secretary of State says that you should grant permission. That's the analysis which I contend for. The material consideration is either in or it's out, and D1 and D2 give us the answer to that question. D2 is a question.
Have we reached the point at which we could look at paragraph 103?
That will be some light relief. So 144 perhaps this is alighted upon because one of the two decisions, locational sustainability, is what is said to be offended by reference to the development plan strategy. And what I think is being said is that the planning system should manage patterns of growth to support these objectives. And at the end of this paragraph, and this should be taken account in plan making and decision taking. Well, in my submission, it's extremely difficult to get any development plan policy into that paragraph. It's simply here a paragraph which is doing two jobs. It's addressing plan makers and it's addressing decision makers as to the government's policy on growth and transport. Doesn't get you into the development plan.
Understood. Now let's stand back, shall we, and see what further submissions you need to make on your main point. You've obviously got to go to two 113. Have you, one way or another, now made the submissions you need to make on the main point?
My Lord, we've made a lot of progress on those.
Take a moment just to reflect.
There is a point which I ought to say a little more about, which is on the topic of standing back in respect of development plans, because paragraph 11 deals with these words in respect of development plans. And I've foreshadowed this submission a little already, but 11b2 is a test, effectively, which an examining inspector will use when looking at a submitted plan. And what an examining inspector will be doing is looking at whether or not the plan is a sound plan, not the sound plan, the only sound plan, or the best plan, but a sound plan. And that is something which is dealt with in the framework. At the end of chapter 3, it's worth just having a quick look at 1, 2, 6. So, in the 2004 Act, we're told that the inspector has to ask whether or not it's a sound plan. Paragraph 35, which is in fact on page 126, the essence of it is there. We're told what soundness is, which of course starts off with meeting need as objectively assessed, and C, effective, which is about deliverability, whether or not it's deliverable over the plan period. Now,
So you're reading from?
my Lord, I do apologise.
You said 126. I wondered if you did mean that.
My Lord, it's page 126.
Oh, sorry. I was looking at paragraph 126.
It's paragraph 35, which
Yeah.
goes over the page from,
Yeah.
and there is a four-part definition of
Yeah.
what is
No,
sound.
I'm with you, and I'm familiar with this. Yes. Yeah. So the submission is?
So the submission is that 11b2 is what an examining inspector is going to be doing in respect of asking whether a plan is sound. And that, in my submission, is consistent with our interpretation of 11d2 for two reasons. One is the words are the same and the exercise is the same. And the second is that there's a relationship between plan making and decision taking, which is, as I've described, a contingency. In the event that what was thought to be sound and would deliver doesn't, then 11d2 is the fail-safe, albeit that it may not be the idle and the perfect solution of having a development plan which deals with it on its statutory basis. So there's a relationship there, and I do draw attention to the startling fact that the words are the same. That ought to be understood in the context of the duty under the 2004 Act to keep plans up to date. That's what the planning system expects. If they're not being kept up to date, then decision taking in 11D seeks to mitigate that.
Right?
And there's a parallel point in relation to the previous version, paragraph 14 of the 2012. They were in a different order, but the plan-making paragraphs are the same as the comparable decision-taking.
My lady, yes.
Yeah.
Great.
Yes.
So, two remaining points to deal with. One is just to say something about circularity, and next to deal with 2.3.
Yeah.
So far as circularity is concerned, that's ground 7. Simple submission, as recorded in the skeleton, is this, which is if, as in particular in Gretton, one starts this 11D2 exercise with an adverse effect being offending the plan's locational strategy, then you're getting a circular reasoning, which is contrary to the purpose of 11D, which is as the contingency, to deal with circumstances where one has such a plan which isn't working. Of course, that's contingent upon that being the actual cause. But all I'm saying is, if you've got a locational strategy which is, for whatever reason, not delivering, then if you go and take that into account in 11D2, then you're diluting the potential to get the presumption in favour. It's a simple point. 2.1.3 isn't a long argument, even though it's a separate issue. The court will find Annex 1 in 2019 framework, tab 9, 176, which is concerned with implementation.
Well, this is policy on how you judge the question whether or not it is out of date.
Yes.
And you give due weight according to the degree of consistency with the framework.
Yes.
So that comes back, that fits, doesn't it, back into paragraph 11D.
And I agree, and the result might be where one has a policy which is inconsistent. That might be something which triggers, gets you into 11D, because the policy is in some respect out of date.
Yeah, I mean, right, I'm not going to open up Hopkins Holmes again, but the question there was how you approach a development plan matrix of policy that wasn't providing enough housing. And there was a constructional question on paragraph 49. But if the 5-year supply wasn't there, the plan, it might be argued that the plan itself was out of date in that, because of its failure in that fundamental respect. The question then was, how do you approach policies that aren't specifically housing policies as such,
Yes.
but they are policies that clearly influence the supply of housing in a restrictive way? That was the whole frame of Hopkins Holmes. And the Court of Appeal solution was one solution. The Supreme Court solution was a different one. But we shouldn't forget that the result was that the appeal was dismissed in Hopkins Holmes. It was a different route. You could say there are two roads to Scotland, but the common denominator is Scotland. High road, low road, destination, Scotland.
Indeed.
This is about one route or the other, effectively.
What it's not about, and this is the central submission, is once you're there in 11D, it's paragraph 213 isn't a means by which you then disapply 11D, which is the complaint in one of these decision letters. So we probably worthwhile to have a look at the paragraph in a moment. But what, in the generality, it's not complicated. It's a route into 11D, and then one has to reach a planning judgment as to the degree of weight to give to the policy depending upon consistency.
Yes, I mean, it gives a, you could say that when you read these policies together, they give a degree of predominance, I'll use that word, to the policies in the framework. Because, if you like, you're judging the out-of-datedness of a policy against the policies of the framework. But that doesn't mean the policies simply vanish and have no force or utility. It's simply a question ultimately of weighting.
I respectfully agree.
None of which actually bears directly on the constructional question that we're seized of here.
The issue goes, in this case, to what we find in the Gretton decision.
Yeah.
If I could invite the court to take up, please, tab 21 in the core bundle and turn to page 330, where we find paragraph 53.
Yeah. Well, does that illustrate the point I've just made, do you think?
In our submission, it is an example of the 213 approach being applied to come to a conclusion that 11D is not engaged, which we say is not correct use of paragraph 213. With respect to the inspector, parts of this paragraph aren't easy to get hold of.
Mm-hmm.
The first sentence isn't at all contentious, it's just the inspectors against the appellant's submission about the strategy, which is essentially one great big block of housing adjacent to Corby. That's neither here nor there. However, this does not take matters any further. Fine. There's no reason why it should be discounted from the supply figure. Fine. I've also preferred the appellant's assessment of housing supply, and then he uses the word "and," which I struggle to understand. But he says the acid test of weight to a policy and any conflicts in such circumstances is the degree of consistency with the framework. And then, referring to the fact of the, he says that the development plan was only considered 3 years ago, since they're fully consistent. And that conclusion appears to feed into the question of whether or not the presumption is engaged. Appears to, paragraph 55, be part of his drawing his conclusions together.
Yeah.
And I say that that's incorrect.
Right.
That's the 213 point. And as to how it should be deployed. So I'm, if I may say so, grateful for the patience that the court has shown with some of the submissions which I've made. The summary is essentially this, still. Firstly, we submit that the line of authorities to Hopkins doesn't really address the issue which is really live in this case. Secondly, Hopkins' points have been very fully debated, but in Hopkins rather less so, so far as the issue that we're concerned with. Thirdly, as far as this framework is concerned, the neighbourhood plan point, paragraph 14, strengthens our argument, doesn't weaken it. We just do what the framework says. Fourthly, we don't accept that the approach which we contend for is in any way complex, and the Secretary of State was keen to submit to the judge below that it was very complicated. We maintain that is not so, exactly the opposite. Because, firstly, our submissions are simply reliant on the text, are consistent with the express purpose in the consultation paper, do not offend the statutory duty, and lastly are on all fours with the City of Edinburgh.
Sorry, your third point.
It does not offend the statutory duty.
Yeah.
And lastly, it's on all fours with the City of Edinburgh in the cases which follow it, such as BDW. So lastly, we submit that in both of these decisions, Litch Green and Gretton, the final planning balance and conclusions both find, firstly, contrary to development plan, fine, but both consider 11D2 is disapplied by incorporating something which should not have been incorporated, pursuant to a correct understanding of the policy. And if they hadn't incorporated that, as I open this, they could well have reached a different decision. Presumption could have been in play, and the ultimate decision is therefore vitiated. And as below, it's for those reasons that we ask the court to send those matters back for the inspectorate, deal with that properly.
Thank you very much, Mr. Kimblin. Let me just make sure. Thank you very much. Yes, Mr. Honey.
The appellant had sought to establish that any consideration of the development plan when conducting the tilted balance would have been unlawful as a misinterpretation of policy. We, as I understand it, have moved away from that today with the acceptance of Crane. That main point was wrong for the reasons that Mr. Justice Holgate gave. The more narrowed, focused approach by reference to Crane is, in my submission, wrong as well. But in any event, neither of the two decision letters in this case falls foul of the challenge, either on the broader basis or the more narrow basis that it's been presented orally. In terms of the structure of my submissions, I was proposing to deal first with the authorities, and in particular Crane, given the concessions made, then Hopkins, Holmes, and the two Court of Appeal cases, going as quickly as I can. Then secondly, DNPPF, to seek to identify the relevant parts. That's both for the construction of paragraph 11D, but also for the context in which that construction has to be undertaken. And again, that is especially important in light of what my learned friend has said about Crane.
On the constructional points, and we're not seeking in any way to draw you further than you are to be drawn, but where you're making submissions that, on as it were, on instructions, are said to be the position of the Secretary of State on the construction of the policy, for what that is worth, I stress, for what that is worth, it would be helpful to us to know that that is what you are doing.
I'm grateful, my lord. I can say that the skeleton argument, for example, was prepared, and indeed the skeleton argument below, but the skeleton argument for this court in particular was prepared having taken instructions from the author of the NPPF. So the court can take certainly the skeleton argument that it has before it as representing, not just, as it were, government litigation arguments, but also the government's corporate position, as it were, on what the NPPF is intended to mean and do. And to the extent that I go beyond that, that again is on instructions, but there may be some points I need to say today where I've gone beyond what I've specifically been instructed on. I'll seek to make that clear.
Of course, and it's well understood, and let me say it lest there be any doubt about it, that as was emphasised by Lord Reid in Tesco and Dundee, a policymaker can never make a policy mean just what he intends it to mean if it doesn't actually mean that.
Yes.
So that is the caveat writ large of which we are well aware.
Yes, I'm grateful, my lord. And then I'll deal with the meaning of paragraph 11D in terms of submissions, the two-stage point that section 38.6 and 11D2 need to be taken as two separate stages, then look at the two decision letters challenged, and then deal briefly with the new ground 9. Conscious of time, if I'm going too fast or too slow, please do not hesitate to be as clear as you need to be with them. So I'll ask, please, Authorities Bundle tab 9 is Crane. Now, in my submission, this is a case which dealt essentially with the argument that is being advanced in this case, but of course before the Supreme Court's judgment in Hopkins Holmes. Page 184, paragraph 21. My Lord Justice Lindblom referred to the plan-led system as an element of the 2012 NPPF, and paragraph 21 here identifies that it was paragraphs 12 and 17 of that version of the NPPF which identified that commitment. Paragraph 25 identifies in particular paragraph 198. And I would ask your lordships, perhaps, my lady, to, with that open as well the supplementary bundle where we have the NPPF to see the current NPPF. There's one paragraph we've not looked at in the new NPPF, page 121 of the supplementary bundle, is paragraph 12. Now, paragraph 12 of the current NPPF is in substantially the same form as paragraph 198 of the old NPPF, but instead of just referring to neighbourhood plans, it refers to the whole development plan, including neighbourhood plans that form part of the development plan. Now, it does say, the current paragraph 12 says not usually, whereas 198 before said not normally. But in my submission, the concessions my learned friend made about the effect of 198 in the 2012 NPPF apply directly to the effect that comes from paragraph 12 of the current NPPF. And of course, this paragraph 12 of the current NPPF was drafted after Hopkins Holmes and reflects what the Supreme Court said in Hopkins Holmes. So I pick that up, as it were, along the way, but I do it because it is important to understand what the reasoning in Crane, as accepted by my learned friend, means now, given the current NPPF. Now covers all the development plan, not just the neighbourhood plan. So when we go on in Crane to look at the reasoning that follows, so for example on page 189, we see the extract from the Secretary of State's decision letter, paragraph 35, and it's quoted in paragraph 26. The Secretary of State there in 26 was clearly treating conflict with the neighbourhood plan as an adverse impact in the tilted balance. What is now 11D2.
So you're referring to paragraph what of Crane?
It's paragraph 35 of Crane and then quoted paragraph 26 below it.
Yeah.
So it's quoting the Secretary of State's decision letter.
Yeah.
And that shows in my submission the Secretary of State was clearly treating conflict with the neighbourhood plan as an adverse impact in the tilted balance, what is now 11D2. Then the actual argument on this, paragraph 57, if I may, first, this sets out the argument about 6 lines down. We've seen such a case, and there's reference to paragraph 14 of the adverse impacts. And then about 10 lines down in paragraph 57, the premise here, says Mr. Hill, is that the development plan has already been considered, and that the balancing exercise at this stage is confined to the policies of the NPPF itself. So that was what was being argued. But we see the same point made in paragraph 59, the second point there in the 5th line. Secondly, the argument is, in concluding that such conflict could be regarded as one of the adverse impacts contemplated in paragraph 14 of the NPPF. The conflict there, if one looks at the 3rd line, is the conflict with the neighbourhood plan. So it was being argued that it was an error of law, a misinterpretation of the policy, to regard as one of the adverse impacts, for the purposes of paragraph 14, conflict with the neighbourhood plan. The claimant in that case was arguing effectively that development plan policy in conflict with it was not to be taken into account in the tilted balance. That was rejected. Paragraph 61, I do not think those submissions are tenable. Cogently argued, answered by Secretary of State, correctly understood, Secretary of State understood NPPF policy correctly and applied it lawfully. So that's endorsing what we saw in paragraph 26 of the Secretary of State's decision letter in that case. Then over the page 196, it's paragraph 66, about 4 lines up from the bottom. Reference there to the presumption in paragraph 14 of the NPPF therefore applied, but in his view that presumption was outweighed for the first of the 2 alternative reasons because of the adverse impacts, especially in terms of the conflict with the neighbourhood plan. And then paragraph 67, that was a conclusion unmistakably expressed in the language of paragraph 14 of the NPPF. That's then quoted. And then about 7 lines down, the adverse impacts here included conflicts with the development plan, especially the conflict with the neighbourhood plan. And then we have paragraph 74, which the court has already seen, where the point is again clearly made that the plan is not to be ignored. The development plan is not to be ignored, not to be put on one side, and it is not the case that the balancing act takes place purely within the text of the NPPF as a whole. Then paragraph 75, first line. In this case, the Secretary of State did what paragraph 14 of the NPPF required him to do. And then about 8 lines down. On the adverse impact side of the balance, he gave very substantial negative weight to the conflict between the appeal proposal and the neighbourhood plan. And then a bit further down, he considered the proposal's conflict with the plan under the policy in paragraphs 183 to 185 and 198. He was entitled, indeed required, to do that. The presumption in paragraph 198 was a consideration to which he was entitled to give significant weight, and he clearly did. He attached great importance to the concept in paragraph 185 that the NPPF neighbourhood plans will shape, direct, sustainable development. And then 76, the same point carried forward, second line, Secretary of State carried out the balance between the adverse impacts and the benefits as paragraph 14 of the NPPF requires, and at the end that betrays no error of law. And then again 78, lastly, 4 lines down, the proposal's conflict with the neighbourhood plan was a powerful and decisive factor. This was not a conclusion beyond the range of reasonable planning judgment to allow a decision maker to make a balancing exercise required by government policy in paragraph 14 of the NPPF. So in my submission, the case makes clear that development plan conflicts can be adverse impacts for the purposes of the tilted balance, and rejects the argument that you ignore development plan policy when conducting the tilted balance in 11D2. But even on the narrower approach of the appellant, the reading of the relevance of the NPPF in Crane via paragraph 198 of the 2012 NPPF, with paragraph 12 of the current NPPF, the same point applies to all the development plan, not just the neighbourhood plan. So whether one reads Crane to be making a general point about the development plan or a specific point focused on paragraph 198 of the neighbourhood plan, the answer when one comes forward to 2019 and looks at these two decision letters is the same in my submission, because of the wording reflected now but wider in paragraph 12 of the new NPPF. So that then takes me to Hopkins Holmes. I'll be as quick with this as I can, as the court has already seen it, but it's behind tab 11. And it may be worth starting just with paragraph 2 on page 222, because Lord Carnworth, with whom all the other judges agreed, makes the point at the end of paragraph 2 that this case was the opportunity to look more broadly at issues concerning the legal status of the NPPF and its relationship with the statutory development plan. So, in a sense, regardless of how one looks at the issue in terms of whether it was the issue here now, whether it was critical in Hopkins Holmes or not, the court was looking at this general question. But my submission is that the specific point that this court is now concerned with was at the heart of what the Supreme Court had to consider, because the way that the Supreme Court unlocked the, I think, doctrinal controversy was the phrase that was used, was by looking at paragraph 14 then interrelated with section 38.6. That was the way that it unlocked that question, how it untied the knot that courts below had been grappling with. On page 225, we see the quote from the old NPPF, and the court has the point, I'm sure, that the phrase, the policies in this framework, appears twice there as it does in the current NPPF. The court has looked at paragraph 14. That is, in my submission, a key paragraph. The Supreme Court is there making it clear that paragraph 14, as it relates to decision taking, cannot be divorced in practice from the development plan, and says indeed some of the references only make sense on this basis. And that is something that in my submission does clearly apply to the use of that phrase in the tilted balance element of the paragraph, as well as the specific policies, giving a clear reason element of it.
Just pause for a second, if you would.
Yes.
Yeah, just going back a step or two to paragraph 10 of Lord Carnwath's judgment. He's referring there to a statutory requirement under section 38(6). That's the quotation at paragraph 10. So that is actually the starting point for this part of his analysis.
Yes. And my submission, my lords, my lady, will be that when it comes to construing the NPPF, the part that we're looking at now, there are two critical elements of context. Tesco and Dundee, of course, made clear that we construe the words used in their context. The first part of the context is the statutory plan-led scheme. The second part of the context is the rest of the NPPF. You take the NPPF as a whole as the context for construing paragraph 11D2. And of course, the NPPF does reflect the importance of the plan-led system, but there are many other elements of the NPPF which I say show that the development plan is part and parcel of the consideration of the tilted balance. It's not sensible to try to divorce the two, as Mr. Justice Holgate observed. Paragraph 21 makes the point at the end of the paragraph that the policy making, as it were, decision making and policy making in the NPPF must be exercised consistently with and not to displace or distort the statutory scheme. And then over the page, this is the quote from Tesco and Dundee, where at the end of the first quoted paragraph, we see the reference to read as always in its proper context, just above D. Then in paragraph 25, there's the reference to the respect to be paid to specialist planning inspectors and at E, specialist judges of the planning court. And then just above F, the point as well about distinguishing interpretation as against application.
Sorry, where are you again?
Sorry, my lord, with paragraphs 25 and 26.
I'm sorry, thank you.
Just at E is the reference to specialist judges of the planning court, and just above F is the point about distinguishing between application.
Yep.
So we then on page 237 have the discussion, interpretation of paragraph 14. And the reference just above H to determine the weight to be given to the policies under paragraph 14. And this is the element that I referred to as how the controversy was unlocked court effectively saying, well, it doesn't matter because you need to consider all the policies and the weight to be given to them under paragraph 14. And what's being discussed there, in my submission, clearly does relate to the tilted balance. The first sub-bullet point in the 2012 NPPF, now paragraph 11D2. Then paragraph 59 over the page. Just below F says the shortfall is enough to trigger the operation of the second part of paragraph 14. That's the decision-making part. And then it says it's that paragraph which provides the substantive advice by reference to which the development plan policies and other material considerations relevant to the application are expected to be assessed. So it's paragraph 14 reinforcing what was said in paragraph 56 that gives the advice by which development plan policies are expected to be assessed. Then over the page, paragraph 61 at the end of paragraph 61, just below B, last 3 lines, the weight to be given to it, it's policy, alongside other material considerations within the balance set by paragraph 14. So
Sorry,
56.
The it is what?
I took it to mean, my lord, a policy.
Yeah, wait a minute.
So it's referring to a recently approved green belt policy,
Yeah.
about 6 lines down.
Yeah, well, yeah, but in a local plan,
Yes,
and that's the it.
yes,
The weight to be given to it, alongside other material considerations, within the balance set by paragraph 14.
my lord.
Within the balance set by paragraph 14.
Yes, so that is echoing the phrase that was used in paragraph 56, which was giving policies weight under paragraph 14. Here it says giving them weight within the paragraph 14 balance.
And that you submit can only be the tilted balance exercise.
Yes, that's the only genuine, as it were, balance within there. Because the other element, of course, well, there's the first element of if it accords with the development plan, we don't get there. The other element is the specific policy giving a clear reason.
Yeah. And of course, Greenbelt policy is set in local plans, not in neighbourhood plans. Lord Carnworth says local plan.
Yes.
So, do you submit also that he's clearly not reading Crane as confining the paragraph 14 point to...
That's right. Hopkins Holmes is deciding the point, as it were, ab initio, but it is entirely in accordance with Crane, and indeed the wider rather than the narrower reading of Crane.
Yeah.
But there are, you know, the court was clearly aware of Crane. It was cited in paragraph 29, for example, of the Supreme Court's decision. So nothing in there, having seen Crane, as they clearly did, was that led them to comment adversely about Crane at all. And if they were coming up with anything that was significantly different, given that they were attempting to give a clear statement of the law, you would have expected them perhaps to say so, at least in the same way that they endorsed law, for example, and the analysis in law as sensible. Then, going on, we have Lord Gill's judgment, which all of the Supreme Court, except Lord Carnworth, agreed with. We then have paragraph 75, at about F, where the guidance relates to decision-making and planning applications. It must be interpreted in all cases in the context of section 70, subsection 2, and section 38(6), to which the guidance is subordinate. So again, making the point, Lord Gill in paragraph 75, that the task of interpretation is in the context of the the statutory scheme, and indeed the NPPF is subordinate to the statutory provisions. And then the reference in 85.
Yes, and I'm just picking up in the middle of 75. While the Secretary of State must have preserved these statutory requirements, he may reasonably and appropriately give guidance to decision makers who have to apply them, that's the statutory requirements, where the planning system is failing to satisfy an unmet need.
Yes.
And that just prompts me to ask you whether, in the light of that, the question I was asking a short while ago to Mr. Kimblin was properly founded. That's to say that paragraph 11, as it now is, 14 then, of the NPPF, is really purportedly telling decision takers how to go about their section 72, section 38(6) duties.
Yes, essentially yes, my lord, I would agree with that. The only caveat I would enter is that this, the tilted balance in particular, applies to different circumstances, including here, where policies are deemed to be out of date because there's no 5-year housing land supply, simply to trigger the tilted balance, without those policies in fact being substantively out of date. So I wouldn't want to go one stage further with what Lord Gill said, and accept that necessarily the lack of a 5-year housing land supply means there's something wrong with the development plan or its policies.
No, I wasn't suggesting that. Yeah, simply to look at 11C and 11D, which are the specific guidance for decision, or policies for decision taking. They are policies which have the status themselves as material considerations, but what they're doing is guiding the decision taker on how to go about exercising the statutory duty itself, within which there are material considerations.
Yes, that's right. So the NPPF accepts that's the statutory framework within which decisions need to be made, and says in these particular circumstances, this is what we'd like you to do. Gives a helping hand, if I can put it that way.
Yeah.
So just finally then, my lord, paragraph 85, there's the reference just...
Well, what about, did you take us to 79?
No, that is the point where one needs to look at, as it were, the effect of the policies when there's not a 5-year housing land supply, to try to judge whether they are in fact the reason for a lack of housing land supply or not.
Yes, but to get the full flavour of paragraph 85, you have first to taste paragraph 79. Because that's the context, isn't it, for what Lord Gill goes on to say at 85.
Yes.
He's specifically on Green Belt at 79, but the development plan policies for the preservation of the Green Belt. And that's the context, is it, for what he comes back to say at paragraph 85?
Yes, that's right, my lord. And then the specific context in paragraph 85, fourth line just above C, is the second branch of paragraph 14, which is the decision-making branch of paragraph 14. And we see just above E the reference to assessed against the policies in the framework taken as a whole. That's the language of what is now 11D2, and makes clear, by reference to footnote 9, I accept, but the policies in the framework cannot mean only policies originating in the framework itself. It must also mean development plan policies to which the framework refers. Greenbelt policies are an obvious example.
So that ties back to 79.
Yes. And I'll when we come to look at the NPPF, I can give some further examples of the many other policies that tie in that way. My submission is that it's so pervasive, it's not feasible to take the approach my learned friend does and see to a light or because it is something which is pervasive in the NPPF. It is intended to work in tandem with development plan policy. But in my submission, we can take 2 points clearly from Hopkins, which is first that the phrase policies in this framework are not confined to NPPF policies, but must extend at least to relevant development plan policies. But secondly, that where the tilted balance, paragraph 11D2, is engaged, the weight to be attached to development plan policy is to be addressed in that tilted balance, now paragraph 11D2. We then have the two Court of Appeal cases which explain, summarise the operation of the tilted balance, echoing the words of Lord Carnwath and Lord Gill, and show first that this is an element of the ratio of the case I indicated earlier, but also, in my submission, do illuminate how to do the task under 11D2. So the first of them, chronologically, is East Staffordshire, which is tab 12. Again, taking it fairly quickly, if I may. Paragraph 13 on page 249, just above F. This is the reference to the NPPF, where the court said, fourth line, explicitly recognises and emphasises its own place in the plan-led system of development control. And then in paragraph 14 at the bottom of that page, a recognition, of course, that the NPPF is a material consideration external to the development plan. Doesn't mean that that works in reverse, that the development plan is external to the NPPF. It goes on over the page to say policy in the NPPF, including the presumption in favour of sustainable development in paragraph 14, operates within the statutory framework for the making of decisions, and a reference there to Crane in that paragraph 14. Then on page 252, paragraph 22, and in particular it's subparagraph 2 at letter D. This echoes the words, the third line, under paragraph 14. So it's giving weight to the development plan policies under paragraph 14. And then over the page, subparagraph 4, again, the echoes the wording, the weight to be given to it alongside other material considerations within the balance set by paragraph 14. So both the formulations that we saw in Hopkins Holmes under paragraph 14 and within the balance set by paragraph 14 were then picked up by the Court of Appeal when explaining the importance of the Supreme Court's decision. And then the final reference here is on page 259. G, there's a reference there to Crane covering paragraph 70 to 74. 74, of course, is the key one that we were looking at earlier. Then Hallam was the case then that followed chronologically. Perhaps we go straight to page 280 there in paragraph 44. 3 lines up from the bottom, we find the same reference to reduced weight under the policy in paragraph 14. And then in paragraph 45 at the end...
I'm finding it very difficult, and it may be because I'm not as familiar as you with these authorities, but just to pick up half a sentence, I'm finding difficult.
I apologise,
So
I'm going too fast.
A sentence, a full sentence would be helpful.
Yes,
I'm so sorry, Mr. Honey.
No, I understand. So the point here, my lady, in particular is that when explaining Hopkins Holmes, we can see from the second line of 44, that's what this part of the judgment is seeking to do.
It does not prevent the decision maker from giving such policies reduced weight. Right, I understand that.
And it is under the policy in paragraph 14. And then it's the last sentence of paragraph 45. As law emphasised in paragraph 61, a restrictive policy, which is of course a policy of the development plan, may not itself be out of date, but the weight to be given to it, i.e. a policy of its development plan, alongside other material considerations within the balance set by paragraph 14. Then in paragraph 46, there's another reference to Crane, just 3 lines up from the bottom, paragraph 70 to 75. So again, picking up the point that we saw earlier. And then there's paragraph 59 as well on page 284. My Lord Justice Lindblom flagged this earlier, which is another reference 4 lines up from the bottom to the balancing exercise provided for in paragraph 14 of the NPPF.
Sorry, the paragraph you mentioned before 59 was which one?
That was paragraph 46.
46, sorry, yes.
And that was simply to flag that 4 lines up from the bottom of 46, Crane is cited, including paragraph 70 to 75.
Yeah, sorry. And then 59 was the passage that we looked at a little earlier.
Yes, my Lord. So it's the penultimate sentence of 59, which again refers to weight being given to conflict with relevant policies of the local plan in the balancing exercise provided for in paragraph 14. So those 2 cases of the Court of Appeal which show that following Hopkins Holmes, development plan policies can be taken into account and weighed in the tilted balance. Paragraph 11D2, and indeed in my submission it shows that there is an interrelationship between section 38.6 and paragraph 11D2, the weighting and the balancing. They're not 2 things which have to be entirely separated. So decision makers are not obliged to leave development plan policies out of account when conducting that tilted balance exercise.
Can we just be clear about one thing?
Yes.
You said, and it was prompted by your last submission, not obliged to leave out of account was the way you put it. Do you put it like that, or do you go further and say that they must take relevant development plan policies into account? How do you put it?
Echoing the Supreme Court in Hopkins Holmes,
Yeah.
They should do it. But 2 caveats. First, it's not an error of law if they don't do it.
Right.
Because there's no hard and fast rule. And secondly, there always needs to be a discretion for the judgment of the decision maker in any particular case as to exactly what development plan policies they're going to take into account when conducting the 11D2 tilted balance. That is, as Mr. Justice Holgate put it, they can be applied together or separately.
Provided they do section 38.6.
Yes.
Ultimately.
Yes. So it's not an error of law if they don't do that, but clearly that's the way the Supreme Court said that it should be done.
And as I understand your submission, because we dealt with this with Mr. Kimblin, as I understand your submission, the relevant part of this case is binding on us.
Yes. Yes. And in particular, of course, we're concerned here with the point of principle because of the way the case is being argued. But there are 2 decision letters being challenged. And as I indicated earlier, even on the narrow reading of Crane, where you have to look for specific parts of the NPPF that cross-refers, the 2 decision letters in this case would be sound under that narrower approach as well.
Yes, just a second. On this whole question of whether it's binding or obiter, just to nail that point firmly down, I did ask Mr. Kimblin about this earlier on. without repeating it all, I sought to encapsulate the real issue in Hopkins Holmes, which had to be tackled, which was ultimately the consequence of not regarding restrictive policies that, for their part, shaped the supply of housing as being policies for the supply of housing under paragraph 49 as a constructional point. To get to the ultimately same destination, having taken a different starting point from that constructional exercise, the Supreme Court did reach the same destination, but an essential stretch of its route, if you will, was the path that you've charted for us through the paragraphs you mentioned in Hopkins Holmes. Is that correct?
Yes. So the Supreme Court said, in a sense, it doesn't matter how far the phrase relevant policies for the supply of housing go, and which specific development plan policies are caught within that, because you look at them all under the tilted balance. That's the way that the Supreme Court reconciled the doctrinal controversy that there had been about the meaning of relevant policy for the supply of housing. And it is critical to the approach the Supreme Court took.
So, does it follow, if I'm being terribly slow, just tell me, does it follow then that if we were to uphold Mr. Kimlin's argument, we would be necessarily going against Supreme Court authority?
Yes, that would be my submission.
Yes.
And indeed going against two Court of Appeal authorities which post-dated, which I think technically are binding on the court, save in very narrow circumstances in any event.
But I mean, you say that those simply follow
Yes,
the Supreme Court.
they summarise or explain, yes.
Right.
A very brief reference, if I may, just to the Wynne-Williams case, seeing as that was mentioned. The court wasn't taken to it, but I can deal with that, I hope, very quickly. And that's in the Authorities Bundle, tab 6, page 78. As I'd understood when I friend Skellis' argument, the Wynne-Williams case was being relied on for support for the proposition that Section 38.6 needs to be dealt with as a separate stage from paragraph 14. But in my submission, that's not how Wynne-Williams should be read, or indeed it's not what it was dealing with. So paragraph 35 at the bottom of page 78 refers to paragraph 14 of the NPPF and identifies that it's got two things. The first bullet, which says where development proposals accord with the development plan, and then the second bullet point, which is where relevant policies are out of date, you have the adverse effects significantly outweigh the benefits. And it says at the bottom of that page, an answer to the question about accord with the development plan is a necessity if paragraph 14 is to be applied properly. But that relates in my submission to the first bullet point under paragraph 14, which is asking whether the development proposals accord with the development plan, what is now paragraph 11C of the new NPPF. We see that also from paragraph 36, the fourth line, where the Deputy Judge says the paragraph 14 presumption cannot be applied until the questions posed by paragraph 14 itself, which include consideration of development plan policies, have first been answered. And that's the reference in my submission to the first bullet point of paragraph 14 as it was, now 11C. It's discussing those two elements of policy. It's not discussing how section 38.6 and the tilted balance interact. So there's no conflict in my submission between Mr. Justice Holgate's judgment and Mr. Elvin's judgment. because Mr. Elvin was focusing on the questions posed by paragraph 14 itself, as he says, not section 38.6. But the second thing I say in relation to this, in both the decision letters before the court, the inspectors did reach express conclusions on whether or not the development complied with the development plan before going on then to consider the paragraph 11D2 tilted balance. The final case that I mentioned, I won't take your lordships, my lady, to it unless it would assist, is the Samuel Smith case in the Supreme Court, which deals with the policy concept of openness and what factors can be relevant to openness, and effectively says that the matters relevant to openness in any particular case, the specific example being visual impact, is a matter of planning judgment. And that was one of the reasons for the slight hesitation I had in response to your lordship's question earlier as to whether or not the development plan is definitely to be taken into account, because there must always be an element of discretion. So, for example, when paragraph 11D2 talks about adverse impacts and benefits, there will be some judgment involved in deciding what are the adverse impacts and benefits which are relevant, and then whether or not they relate to development plan policies which are to be taken into account. So it's not necessarily the case that there is a direct correlation between what's relevant in 11D2 and what would be relevant in section 38.6, which is my slight hesitation about saying that they must always be dealt with together. Why, in my submission, Mr. Justice Holgate was right to say they can be dealt with together or separately. And I'll seek to explain particularly what I mean by that when I come to deal with the application of paragraph 11D2. So I'm conscious of the time, but I was going to embark on the NPPF.
Yes, you carry on. Yeah, no, we'll carry on. I think what we'd like to do, if you feel able, Mr. Honey, is to carry on and deal with this part of your submissions in any event this evening. Can you do that?
I'm content to try. Please tell me when you want me to stop. I'm happy to break at any time and start again in the morning. So if I'm going on later than you anticipated.
Well, we'll sit. If this is not going to cause discomfort or problems for anybody, we'll sit a little beyond 4:30 just to do that. Don't feel under any pressure. If we find that we haven't made that much progress by then we can take a view.
I'm grateful.
But we're keen to do as much today as we can, at least.
Thank you. So I was going to begin. We're in the supplementary bundle. Tab 9 is the current NPPF.
Yeah.
I begin at page 118. Paragraph 2 makes the point by reference to section 38.6 about how to approach the determination of planning applications, and that the NPPF is a material consideration. And then paragraph 3 makes the point that the framework should be read as a whole. And that's something which applies generally to the framework, not just specifically in the context of paragraph 11.
Yes.
Then paragraph 11D2, page 120.
Yes.
11D2 does, of course, only expressly refer to the policies in this framework. But we know, in my submission, we know from Hopkins Holmes, which predates the publication of this, what that means. But the wording in any event, my submission would be, even if we didn't have Hopkins Holmes, that the wording does not mean that you can have no regard to any policy other than one which is contained in the NPPF, or indeed any one other than which is expressly cross-referred. There will be a range of government policy documents beyond the NPPF which could be relevant to inform this tilted balance. There are white papers, written ministerial statements, other policy documents of that sort, in addition, of course, to development plans adopted by local planning authorities.
Why wouldn't it say including in this framework, if that was right? Why choose to word it in the way that it has, if you're right, that it encompasses all policies, wherever they may be?
Well, it may. And that's a matter for the judgment of the decision maker, which other policies to take into account. The fact that it refers only expressly to policies in the NPPF does not make irrelevant any other policy document.
So it's just making sure that the decision maker takes account of the policies in the framework, but it's not excluding him or her from taking account of other policies.
Exactly right, yes. And Hopkins Homes, of course, was about development plan policies, and they have a special status because of the statutory scheme, which is recognised expressly in the NPPF.
And does that also applies to B2, 11B2?
Yes.
Because the other policies there, I think, logically, can't relate to development plan policies because we're talking about the development of the plan, the creation of the plan. But you say that it could refer to other policies, not development plan policies, not NPPF policies, but other policies that are there.
Yes, but it could refer to other development plan policies in the hierarchy. We've moved away from the approach of having a core strategy and documents underneath it, but many local authorities still take the approach of having a main plan which sets out the overall spatial strategy for an area, and then having maybe a detailed development management policies plan or an area related plan.
Yeah.
So it could encompass other elements within the development plan as well, and that in my submission is a good example of why it shouldn't be confined in its meaning, because when one is asking oneself what is an adverse impact, why should the decision maker be cut off from considering any other policy document except the NPPF? It ought to be a matter of judgment in the circumstances of the case for the decision maker which other policy documents they go to, subject to the point that Hopkins Homes tells us about development plans because of their particular status.
Just pause for a second. I'm sorry to ask you to do that again. Back to Hopkins Homes. I just want to pick up what Lord Carnworth said. I mean, clearly the policy was in the same terms in its material part here. Is that right? I mean,
Yes.
They reversed the order
Yes.
to make it logical. But the tilted balance policy hasn't changed in terms.
That's right.
I don't think at all, has it?
I don't think at all.
I mean, I think it's exactly the same language, isn't it? Right, maybe it does retread territory that you've covered already. Yeah. When you read, just to nail this point clearly, when you read the whole of the passages you took us to in Lord Carnworth's judgment, Can there be any suggestion that he was confining his observations about the relevance of the development plan to what is now 11D1? I don't think there can if, for example, you look at paragraph 54. Where he's specifically dealing with the tilted balance. And so in 61, can there be any suggestion that he's dealing only with the other limb?
No, because the words are talking about a balance in paragraph 14. Yeah. The only balance in the relevant part of paragraph 14 is this tilted balance, because the other element of it, the clear reason element, the wording of that has changed, but the essence is still the same. That doesn't involve a balance in the same way. It's a kind of knockout blow or not. It's not a balancing exercise.
Yeah. So Lord Carnworth must be referring to the tilted balance in Hopkins Holmes.
Yes, and indeed, in my submission, that's how it's been understood by the Court of Appeal in those two cases subsequently.
And he's referring to precisely the same policy formulation?
Yes, in what I'm calling the tilted balance.
Yeah.
11D2 as it is now.
All right, I'm sorry if I'm straying, but forgive me for the moment. I'm just going to pursue another point with you.
Yeah, I mean, just simply to finish, it cannot be the case in my submission, reading the words of paragraph 11D2, that all policies other than the NPPF, or even all policies other than those expressly referred to by the NPPF, are entirely and legally irrelevant to the tilted balance exercise. So it would be an error of law to take them into account.
Yeah.
The
point I was going to pursue, you've finished that submission, but do forgive me. If this causes us delay, then I'm sorry. Question. In the new formulation of the policy in 11D, why is the footnote 6 applied only to the knockout blow provision? Or is it? Might be the question. There are two questions there, actually. First of all, is it, as appears on the face of the text, applied specifically to the knockout blow, and only the knockout blow? Or is it meant to be read as applying to the tilted balance as well as the knockout blow?
It only applies to the knockout blow.
Right.
That, of course, is in B1 as well as in D1. And as to why, that is because, I'm cautious, of course, to trespass on anything that may have arisen in the Monk Hill case, but when that was argued. But those are because those are the really important things that can provide a knockout blow.
In other words, the explanation that I ventured for Mr. Kimlin's comment.
Exactly, my lord, yes. And it's important.
So it's preserving the balance, in effect. It's saying anything else other than those particular policies, you've got to conduct an assessment and a balancing exercise.
Yes.
It's only those particular policies that can be a knockout blow.
That's right, my lady, yes. And perhaps we can go, if I could just break off and ask the court just to return very briefly in the core bundle to the consultation document, because I think it says almost that in terms. So this is the core bundle tab 12.
So it's all right to look at the consultation document.
This is the consultation document or the document that we're construing. I quite take
That's
your
all right.
Lordship's point that we're potentially going beyond context and into the forensic archaeology, as I think it's been described in previous cases, looking into the history of the policy.
Yeah.
Certainly a consultation on an earlier iteration of the NPPF, I would hesitate to say that that should always be accepted as part of the context. But
Well, you might describe that as prehistoric archaeology, whereas this is merely historic.
yes, it's much closer in time.
All right, so we're going to look at it.
Yes, page 190.
19.
Page 190. Well, perhaps if we
In the-
start on 189.
Tab 12.
Oh, sorry, I'm in the wrong bundle.
It's the core bundle, my lord, I'm sorry.
I beg your pardon. Yeah.
So this is the consultation document, page 189. It says in the middle of that, just above the chapter 1 introduction heading, the section below outlines the main changes proposed in the framework. And this, of course, was post-Hopkins Holmes. So what the framework was doing was continuing an understanding of the NPPF as interpreted and explained by the Supreme Court in Hopkins Holmes. Nothing was changing. What it does identify over the page at the top of 190 is that it was changing to a defined list the examples of policies which provide a specific reason for restricting the development. So it is making it clear in my submission that it was only the 11D1 clear reason element that was changing, nothing else. And then it goes on to say, and this is my Lady Justice Simler's point, this approach does not preclude other policies being used to limit development where the presumption applies, if the adverse impacts of granting permission would significantly and demonstrably outweigh the benefits. So it was preserving, as it were, the wider approach under the tilted balance, but introducing a narrower defined list for D1, but only for D1.
Preserving the wider approach for the tilted balance.
Yes. So if we then return to that footnote as now amended, which is supplementary bundle tab 9, page 120, we see the words in footnote 6, first line, that were introduced, rather than those in development plans. Those words in brackets were introduced to the Supreme Court's decision in Hopkins Holmes and in response to it. I can say that was within the scope of your Lordship's point of being clear when I'm saying something on instructions. That text in brackets, rather than those in development plans, was introduced to, as it were, reverse the effect of the Supreme Court's wider view of the phrase policies in this framework, but only in relation to D1. No change intended to D2. That was continuing to be interpreted in the light of Hopkins Holmes. So the exclusion of policies in development plans was clearly flagged, clearly made, but relates only to D1. No such exclusion as far as D2. There is, in my submission, then nothing to change the meaning of the phrase, the policies in this framework, from that set out in Hopkins Holmes in the Supreme Court.
And you say you have specific instructions on that?
So there was no intention to change from Hopkins Homes except where it's stated in that point in footnote 6. And the wording of paragraph 12 that I showed the court at the start of my submissions reflects Hopkins Homes as well. So this is a change in the wording of the NPPF. Paragraph 12 compared to old paragraph 198. But it is not a change in substance because it was simply reflecting the approach of Hopkins Homes.
And is that also on instructions? That point?
I would hesitate to say definitely.
Well, don't then.
So I won't. Just to be absolutely clear.
Fine. Don't speculate on that. That's important.
So my submission is that paragraph 12 is the equivalent of what we found in paragraph 198 of the 2012 NPPF as considered in Crane, but clearly covering the whole development plan and not just the neighbourhood plan as it was in Crane. I'm afraid I hesitate in terms of the instructions point simply because this is come into particular importance as a result of the way the case was put this morning. I'll see if I can take instructions overnight or at least before we start again in the morning.
Right, now let's just pause for a second. We're now at just after 4:30. Have you said more or less all you want to say about paragraph 11 at the moment?
Yes.
Right. But you've got other things to say about other paragraphs.
Yes.
Would that be a convenient moment?
It would, my lord, yes.
Are you happy to stop? Yes. You're happy to stop now? We'll stop now then for the day. We'll resume tomorrow. Now there is, albeit to be conducted remotely, a single or justice application tomorrow morning, which is listed ahead of the resumption of this case. I think it's to be listed, or has been, at 9:30, and accordingly, given the indications as to time in that case, we shall sit again not before 11 o'clock. I think that will be the time marking. If it's not the time marking that's fed its way through, then that is what I'm saying now. So it will be not before 11 to resume this hearing tomorrow. And with a view, we hope, to finishing before the normal midday adjournment.
I will be as quick as I can.
Thank you both very much. Thank you all three of you very much.
All right.